Dear students, welcome to EPG Pathshala. The topic for today's discussion is control of hazardous waste. Dear students, we all know that the mankind has witnessed rapid industrialization. In the name of development, every country, developed as well as developing, has witnessed a shift from agricultural economy to industrial economy, and the need and desire for having more and more consumer products and to have more and more consumer comforts have led to not only heavy industrialization but also manufacturing of various chemicals, compounds, and the need for power generation, electricity. And what has happened therefore is that there is large scale increase in the manufacturing of hazardous chemicals, atomic plants, compounds, and this has led to generation of toxic wastes. These toxic wastes are dangerous to mankind, they are harmful to animals and to flora and fauna. They are polluting the environment, and at certain places it has been seen that the places have become unfit. The water has been made unfit for human consumption, and at certain places the chemicals have percolated so deep into the bowels of the earth that the entire water table has become corrupt, and people are suffering from various ailments like cancer and the like due to the increased use of these chemicals and the waste generated by these chemicals. In this backdrop, we will be discussing the legal provisions pertaining to control of hazardous wastes. The learning outcomes of this module shall be to learn about, to discuss and analyze legal regime pertaining to hazardous processes, because these hazardous processes would generate hazardous waste also. We will also be discussing legal and regulatory regime regarding the storage and disposal of hazardous waste. How the hazardous waste can be stored, how it is to be disposed of, whether it is to be disposed of on land or dumping at sea, dumping at land, or by incineration. All these things, along with, we will be discussing the judicial decisions in this matter. The scheme of the presentation will be, first of all, we will be introducing the topic, and then we will discuss the legal regulatory mechanism pertaining to hazardous processes, legal regulatory mechanism relating to hazardous waste, and the judicial decisions on these topics. As we said, that the rapid industrialization has led to manufacturing of various chemicals and chemical byproducts. These increasing use of chemical byproducts has led to generation of increased hazardous waste, which is hazardous to animals, environment, plants, flora and fauna. Not only that they are polluting the environment, but these hazardous wastes can also lead to major accidents. Dealing with hazardous processes, the world has witnessed accidents like Chernobyl accident, we have witnessed Bhopal gas tragedy, and therefore the attention of the world has been drawn towards the safe disposal of hazardous waste and the safe regulation of hazardous processes. And therefore, there is a need for effective and efficient disposal of hazardous waste and also for safety of hazardous processes. In this backdrop, before we discuss the topic, let us have a look at the report of the Central Pollution Control Board of 2014-15. As per the report of the Central Pollution Control Board of 2014-15, in India, there were 42,429 industries which were producing 7.8 million tons of hazardous waste annually. Of this, 3.37 million tons waste was landfillable, 3.82 million tons waste was recyclable, and 0.61 million tons waste was incinerable. This is the quantity of waste which is generated annually in India as per the report of Central Pollution Control Board of 2014-15. Keeping in view the quantum of waste generated in India, it is required that some legislative measures are taken for the effective and efficient disposal of hazardous waste. And Indian Parliament has not lagged behind. Various legislations have been enacted before the independence as well as after the independence. If we have a look at the laws enacted by the Union, they include Indian Petroleum Act of 1934, Factories Act of 1948, Inflammable Substances Act of 1952, Atomic Energy Act of 1962, Insecticides Act of 1968, Indian Boilers Act 1923. Then we have Public Liability Insurance Act 1991. Not only we are having Environment Protection Act of 1986, but we have various provisions in the traditional laws of the country, like Indian Penal Code. We have some provisions in IPC 1860. We have provisions in the Code of Civil Procedure 1908, as well as in the Code of Criminal Procedure of 1973. If we analyze the Indian legislative approach, we find that the Indian approach regarding dealing with hazardous processes and hazardous waste concentrates upon regulating and controlling the location of establishments which are generating hazardous waste, providing for the safety of workers and people who are living in the vicinity of these establishments, making provisions for the liability of the occupier or owner in case of accidents, and enactment of various rules regarding disposal of hazardous waste, disposal of solid and municipal waste, plastic waste, e-waste, biomedical waste, construction and demolition waste, etc. Our scheme will be first to analyze the legal framework regarding hazardous processes, then we will be dealing with hazardous waste. Bhopal gas tragedy led the country to make an amendment in the Factories Act by way of Amendment Act of 1987. That amendment introduced Chapter 4A in the Factories Act 1987 to include various sections like 41A, 41B, 41C, D, E and F. Now these provisions provide for or analyze the hazardous processes. They are defined in the Act to include any process or any activity in relation to specified industries involving the use of raw materials, byproducts or wastes which would be detrimental to health or which are likely to cause pollution unless special care is taken. Now you see the definition of hazardous process itself under the Factories Act includes within itself that any industry which uses hazardous waste or which uses any other raw material or byproduct or which generates hazardous waste which would be detrimental to the health or which is likely to cause pollution, that is included within the provisions of the Factories Act as a hazardous process. And the liability is cast upon the occupier of any factory who wishes to have a hazardous process in his organization to obtain the previous sanction of the government before initiating any hazardous process. That means after the commencement of the Act, Amendment Act of 1987, Factories Amendment Act, any new industry installing hazardous process, having hazardous process is required to obtain the consent of the sanction of the appropriate government. Already existing industries, they have also been made liable to apply for consent within the permitted time. The liability is cast upon the occupier to make sure that the workers working in that establishment where the hazardous processes are going on, which are using hazardous waste or producing hazardous waste, that those workers, their medical examination is done at the beginning of the employment, at the end of the employment and at regular intervals, so that the effect of the hazardous waste on those workers can be analyzed. Not only that, the occupier is required to make arrangement for the medical examination of the workers, but the provisions have been made where the occupier is liable to inform the workers, inform the local authorities about the exposure, how much exposure of hazardous chemicals, hazardous processes, hazardous waste will be made to the workers and people living in the vicinity. And this information is required to be given. The occupier is required to prepare plans how this hazardous processes will be dealt with, what are the emergency plans therefore. Before these industries can be established, as we said, there is a requirement for obtaining the sanction of the government, and therefore Factories Act has mandated the constitution of site appraisers committees by the state government. These site appraiser committees are to advise the government, advise the state government about the location of the industries involving hazardous processes. They are to advise the government within 90 days. Once an application is made, within 90 days, they are to advise the government regarding the location of those industries. Even the already existing industries, as we said, which are involving hazardous processes, they are required to inform the chief inspector of factories, the local authority and the public about what will be the quality of the waste generated by them, how the waste generated by them is intended to be disposed of. If we look at the composition of the site appraisal committees under the Factories Act, this committee shall include Chief Inspector of the State, who shall be the chairman of the committee, members of the Central Pollution Control Board and State Pollution Control Board, representatives of the State Department of Environment, representative of Meteorological Department of India, expert of Occupational Health, and representative of State Town Planning Department, scientists having knowledge of hazardous process, representatives of local authority, and 3 other persons to be nominated by the state government. If we look at the Act in general, Factories Amendment Act 1987, it adopts a comprehensive approach. If anybody has applied for the sanction under the Factories Act, Amendment Act of 1987, he is not required to have a separate sanction under the Water Act or under the Air Act. So the sanction given under this Act will be a comprehensive sanction which would cover the requirements of Water Act as well as the Air Act. Now students, we will be moving towards the legal framework, discussion on the legal framework dealing with hazardous waste simpliciter. As we said that there are various laws and bylaws, regulations and rules which have been framed by the governments from time to time dealing with various categories of waste. For example, we have atomic energy, safe disposal of radioactive waste, rules of 1987 made under Atomic Energy Act of 1962, manufacture, storage and import of hazardous chemical rules of 1989, batteries management and handling rules, construction and demolition of waste management rules 2016, hazardous and other waste management and transboundary movement rules of 2016, manufacture, use, import, export and storage of hazardous microorganisms or genetically engineered organisms or cell rules of 1989, chemical accidents emergency planning, preparedness and response rules 1996, atomic energy factories rules of 1996, ozone depleting substances regulation and control rules 2000, atomic energy radiation protection rules 2004, atomic energy radiation processing of food and allied product rules 2012, biomedical waste management rules 2016, solid waste management rules 2016, e-waste management rules 2016, plastic waste management rules 2016. So there are plethora of rules dealing with disposal of waste. Of these rules, some of these rules have been discussed in details in other modules of this MOOCs course. Therefore, we shall be dealing only with those rules which have not been discussed elsewhere in details. Hazardous and other waste management and transboundary movement rules of 2016. We shall be briefly referring to them because these have been discussed in details in other modules also. If we look at these 2016 rules which have replaced the rules of 2008, these rules define hazardous waste. Hazardous waste has been defined as any waste which by reason of characteristics such as physical, chemical, biological, reactive, toxic, flammable, explosive, corrosive or any other properties causes danger or is likely to cause danger to health or environment, whether alone or in contact with some other waste or substances. So hazardous waste have been comprehensively defined in the rules of 2016, and these hazardous waste include the waste specified in Schedule 1 or those waste which possess the characteristics which are specified in Class C of Schedule 2, or those waste with concentration limits equal to or more than that which is specified in Schedule 2. It also includes waste specified in Schedule 3 Part A, catering to import or export of hazardous waste. So if we see the rules of 2016, that is hazardous and other waste rules of 2016, in the schedules they have comprehensively given the list of processes, hazardous processes, as well as the list of rules, list of chemicals, list of wastes, along with the concentration limits, which shall be deemed as hazardous waste. If we look at some of the features of these rules of 2016, these rules have made comprehensive provisions for the management and disposal of hazardous and other waste, including the transboundary movement of these rules. These rules have replaced 2008 rules, and they are expected to ensure recovery of the environment, and also to ensure disposal of the hazardous waste in an environment-friendly manner. These rules have been framed in consonance with Sustainable Development Goals. These rules are first of its type, which have tried to distinguish between hazardous waste and other waste. And these rules enlist the responsibilities of the occupier for safe handling of the waste and safe handling of the hazardous processes in a manner which is environment friendly, and their disposal in a manner which is environment friendly. The rules provide that hazardous waste is required to be disposed of at captive treatment plant or captive treatment storage and disposal facility, and therefore the rules provide for the establishment of common hazardous waste treatment and storage facility where these hazardous waste can be disposed of. Hazardous waste like lead acid battery, used oil, etc., which are to be used as raw material by industries involved in recycling. The rules have made provisions for these processes also. Even the rules contain the list of processes which are generating hazardous waste. These are enlisted in various schedules. The rules have prohibited the import of waste oil, waste edible oil, used animal oil, household waste, plastic waste, etc. State governments have been mandated to allocate industrial space for recycling or utilization of hazardous waste, and the responsibility is cast upon the state government to undertake skill development activities for ensuring safety and health of workers. Further liability is cast on the state government for registration of workers which are involved in recycling or pre-processing of waste with the government. So if we look at the rules of 2016, they have made comprehensive provisions not only for the safe handling of the hazardous processes, but also for the environment-friendly disposal of the hazardous waste. If we look at the ground realities, as we said, as per the report of Central Pollution Control Board, 7.8 million tons of waste is generated annually in India by 42,429 industries. This much quantity of hazardous waste, not only that we are generating, but then in the garb of import, the courts have recognized that the country is becoming a dumping place for dumping of hazardous waste, and therefore there is a need for the effective implementation of the rules of 2016. Going ahead with another category of hazardous waste, which are dealt with in atomic energy, safe disposal of radioactive waste rules of 1987. These rules have been enacted under the Atomic Energy Act of 1962, and these rules provide for the regulation and control of disposal of radioactive waste. These rules also provide for the institutional control of radioactive waste, and these rules prohibit the unauthorized disposal of radioactive waste, along with prohibition on the disposal of these radioactive waste in contravention of the prescribed norms and conditions which are prescribed in these rules. Any institution which is having or which is dealing with atomic energy and radioactive waste, or which is generating radioactive waste, is required to apply for the consent of the appropriate authority. That consent is required to be applied for in Form 1, and that application shall contain the information which is given on this slide, that is, the details of the process, material and equipment generating the radioactive waste, details of equipment and systems installed for controlling the volume and release of that waste, process and equipment employed by that installation or that premises for conditioning, treatment and disposal of radioactive waste, detail of staff employed for disposal of waste, estimated volume of emission and leakage of waste from repositories and their impact on environment, analysis of potential accidents that may occur, detail of safety devices to contain radioactive effluents and control on their release to unrestricted areas, information about the environment around the installation, procedure to be followed for safe collection of radioactive waste, estimate of annual quantity of radioactive nuclides expected to be released in liquid form, in solid form or in gaseous form, and design features of surveillance equipment for monitoring the release of radioactive waste during normal times as well as in case of an emergency. Now, all these information is required to be furnished in the application for grant of consent to the competent authorities. Once the consent is if the application is in order and it complies with the requirement, the consent shall be granted for the period mentioned in that sanction order, subject to the conditions which may be levied, which may be enforced. The consent is valid subject to those conditions only. These organizations to whom the consent is given, they are required to furnish information. They are required to first maintain the record of the waste disposal, waste generated and the waste disposed, the manner in which they have disposed it, and this information is required to be furnished to the competent authority. The information required to be maintained is the description, the quantity, the physical state, the chemical properties, the date of disposal of each consignment containing radioactive waste, the mode of disposal, concentration of radioactive material in the waste disposed of, names of workers who are associated with disposal of radioactive waste. Such organizations are required to appoint RSO, that is Radiological Safety Officer, who shall be associated with the disposal of radioactive waste. His name is required to be furnished to the competent authority. Details about periodic radiation surveillance in and around the site of disposal of radioactive waste, that is also required to be furnished, and such other information as may be required by the competent authority from time to time shall be furnished to the competent authority. As we said, that it is the duty of the installation to whom the consent has been granted to appoint a Radiological Safety Officer, RSO. His appointment shall be with the approval of the government, and not only that he shall be appointed, but there is a requirement of submission of quarterly report to ensure that the operation of the installation is not likely to cause hazardous accident. Further, provisions have been made to ensure that only the essential staff remains in the restricted area and the entry of unauthorized persons in the restricted area is banned. And for this, the installation is required to make adequate arrangement. These installations cannot be decommissioned or cannot be closed unless the sanction of the competent authority has been obtained. even when they have been ordered to be closed down for violation of the provisions of these rules, the competent authority can grant them direction to prevent unauthorized entry of persons in the restricted areas and for the safe disposal of radioactive waste. As we discussed, that these installations are required to appoint a radiological safety officer. The duties of this radiological safety officer shall be to advise the employer regarding safe handling and disposal of radioactive waste, to guide and instruct the workers who are engaged in the disposal or handling of radioactive waste regarding safety measures, hazards of excessive exposure, work ethics, and practices and measures to prevent contamination. He is also required to ensure that the buildings and laboratories used for disposal, storage, etc., they are designed in such a manner so as to ensure safe handling and disposal of radioactive waste. RSO is required to ensure that the safety equipments are of the approved specifications and they are always kept in proper working conditions. If there is any untoward incident or if there is an accident, he is required to immediately inform his employer as well as the competent authority so that emergency measures can be initiated. The rules of the Atomic Energy Safe Disposal rules also make provisions regarding hospitals and tracer research laboratories which are using very small quantity of radioisotopes of very short effective life. If they are used in medicine by the hospitals and tracer research laboratories, rules provide for the registration of those hospitals and those research laboratories. The application is required to be made in form number 5 for disposal of radioactive waste. Radioactive waste generated by hospitals and tracer research laboratories can be disposed of if it is readily soluble. Then it can be disposed of in sanitary sewage system if the quantity does not exceed the prescribed limit, that is, it does not exceed 37 becquerel per annum. Solid radioactive waste is required to be disposed of by burial in pits which are prepared in exclusive burial grounds subject to the fulfillment of other conditions as may be prescribed. The conditions are prescribed in the rules itself, that there should be adequate gap between burial pits. The entry of unauthorized persons in those burials should be banned, and then the radioactive monitoring surveillance is required to be done under the rules. Moving ahead with manufacture, storage and import of hazardous chemical rules of 1989. These rules have been enacted by the central government under section 6, 8 and 25 of the Environment Protection Act of 1986. Rules do not define hazardous chemicals, but rather those chemicals are enlisted in various schedules which are treated as hazardous chemicals. Various authorities which are dealing with these manufacture and import of hazardous chemicals, they are specified in the Act itself. Long range of authorities is given, starting from Ministry of Environment and Forests to Ministry of Defense, including DRDO, Defense Research and Development Organization, including Chief Inspector, Chief Controller of Imports and Exports, Chief Controller of Explosives, Atomic Energy Regulatory Board, Chief Inspector of Mines, Chief Inspector of Dock Safety, Chief Inspector of Factories, Central Pollution Control Board, State Pollution Control Board, District Collector, District Emergency Authority, Directorate of Explosive Safety, etc. All these authorities have been given certain duties under these rules of 1989. The rules prescribed procedure when any institution, any establishment which is dealing with these rules, these chemicals, they are required to obtain the consent. For that, they are required to file an application. The application shall contain details of the hazardous chemicals. Application is required to be filed at least 3 months before the commencement of the activity by the institution. Not only that they are required to give the details of the chemicals, but they are also required to give a safety report containing such particulars as may be prescribed. They are required to prepare an on-site safety plan and an off-site safety plan. Both the plans are required to be submitted along with the application for consent. They are also required to notify who are the persons to be contacted, who are the persons who shall deal if there is an emergency. That means they have to prepare, as we said, off-site and on-site on-site emergency plans, and the persons to be contacted who will deal with them, their names, and the safety precautions which may be taken if there is an accident. If there happens an accident, the institution, the establishment is required to furnish a report immediately to the competent authority, and the competent authority is required to prepare a detailed report as to the nature of the accident and the nature of releases into the environment. The body is also required to examine the site of the accident and to prepare a detailed report, and the report is required to be submitted to Ministry of Environment and Forests. If we look at the provisions of import of hazardous chemical rules of 1989, we find that when these chemicals are imported, within 30 days of import, the information is required to be given to the concerned authority, along with the names and addresses of persons who are going to receive the consignment in India, that is required to be intimated, from which port these chemicals will enter in the territory of India. Complete product safety information is required to be furnished, and once those chemicals arise, they arrive in India, and if the authority apprehends that there can be an accident, then the authority is required to take appropriate action, including their entry of those, banning the entry of those chemicals and safe disposal of those chemicals. This apart, as we discussed in the beginning, that there are various rules dealing with hazardous waste. One of them is Batteries Management and Handling Rules of 2001. These rules have also been notified by the Union Government under the Environment Protection Act of 1986, and these rules provide for the management and handling of used lead acid batteries. These rules impose liabilities upon the dealer, importer, recycler, manufacturer, assembler, reconditioner, consumer, and auctioneer of lead acid batteries. Not only that the dealers, the manufacturers, they have been made liable, but the consumer and bulk consumer, they have also been made liable under these rules. And there is an obligation on the importers and recyclers that they are required to get themselves registered under these rules. As we said, that the manufacturer, importer, assembler, dealer, reconditioner, they have certain liabilities. Their responsibilities include that they have to collect the used lead acid batteries against the new batteries sold, and they have to ensure that the batteries collected and sold are of similar type and specification. It is their duty to ensure safe transportation of lead acid batteries and to ensure that no damage is done to the environment during the transportation. They are also required to create public awareness regarding the hazards of lead. And most importantly, they are required to buy recycled lead only from the registered recyclers. There is a complete ban on buying lead from unregistered recyclers. Liability of the manufacturer has also been there. They are required to file half-yearly returns of sales and buyback to the state pollution control boards. Consumer, as we said, consumer as well as bulk consumer, they are also made liable under these rules. They are made liable to return the used batteries. Bulk consumers like departments of the central government or of the state government or the Indian Railways or Defense and other government organizations, they are required to ensure that used batteries are deposited with the dealer or with the manufacturer or with the registered recycler or reconditioner. Dealer is also required to file a half-yearly return, but dealer is required to file a return with the manufacturer. Manufacturer is required to file a return with the State Pollution Control Board. Auctioneer is also made duty-bound under these rules to ensure that the used batteries are auctioned only to registered recyclers and to no one else. Moving forward to another category of waste management rules, these are Construction and Demolition Waste Management Rules of 2016. These rules have been published in the official Gazette on 29th of March 2016. These have been enacted by the Union Government in pursuance of Section 6 and 25 of the Environment Protection Act 1986. These rules make a provision for responsibility of waste generators, stakeholders, and for segregation, recovery, reuse and recycle of construction and demolition waste. Now, who is a waste generator? Waste generator can be any person. It can be an institution. It can be a commercial establishment or a residential institute, a person having a residential building or establishment like railways, airport, harbor or defense establishment who undertakes construction or demolition work and which is generating construction and demolition waste. Now the rules provide that a waste generator who generates 20 or more tons of waste per day or 300 tons per project in a month, they are required to collect and segregate concrete, soil, steel, wood, plastics, bricks and mortar. All these things are required to be segregated and they are required to ensure that these wastes do not get mixed with other solid waste and they are disposed of separately. Those bulk waste generators, that means those who are generating more than 20 tons of waste per day or 300 tons per project in a month, they are required to obtain prior permission before starting construction or demolition work, and then they are also required to submit a plan, detailed plan regarding the waste management. They are also required to ensure that the waste is kept either inside the premises or they are handed over to an authorized processor, and that there is no littering or no obstruction to traffic or public, or there is no obstruction caused to drains. Service providers, that is the authorities which are providing services like water, sewerage, electricity, telephone, roads, etc. Responsibilities have also been cast upon them, because these service providers also generate demolition waste during excavation, demolition and civil work. They are required to prepare a comprehensive waste management plan and to submit the same. They are required to remove any construction and demolition waste and clean the area every day. Local authorities are required to safely dispose of demolition waste which is contaminated with hazardous or toxic material or nuclear waste. And they are also required to issue detailed instructions pertaining to management of demolition waste which is falling within their jurisdiction. They are also required to identify sites for storage, recycling, processing of construction or demolition waste. Now, having analyzed various rules pertaining to hazardous waste, let us see the judicial trends, or what has been the approach of the judiciary. Let us discuss this Research Foundation for Science, Technology and Natural Resource Policy versus Union of India 2012 judgment. Now, if we look at the facts of this case, in this case, hazardous waste were being imported in the country under the garb of recycling. Permission was of course granted by the Ministry of Environment and Forests for import of these wastes. The petitioner contended that India has become virtually a dumping site for dumping of hazardous waste and chemicals. And he contended that the import of these wastes is contrary to Basel Convention and that offends Article 21 of the Constitution of India. After going through the facts of the case, the Supreme Court of India ordered for proper implementation of hazardous waste rules, batteries management and handling rules. Supreme Court also ordered the central government to inquire into the issue of disappearance of hazardous oil from authorized depots. Because what came to the knowledge of the court, that in certain cases the oil imported, the waste oil imported, that has disappeared from various ports in India, and that oil is hazardous. Therefore, the court directed the central government to conduct an inquiry into the matter. They also required the central government to track the illegal import of hazardous chemicals, and the Central Pollution Control Board was also directed to prepare an inventory of hazardous waste dumping sites in India. This apart, the court ordered a complete ban on import of all those hazardous wastes which are banned under the Basel Convention. Let us see another case, that is Indian Council for Environmental Action case of 1996. In this case, the production of H-acid industries, these H-acid industries were contaminating the land as well as the water was getting contaminated. Therefore, a petition was filed against those industries which are producing H-acid, because this acid, sulfuric acid, is highly toxic sludge. It generates highly toxic sludge, and if this is untreated and that untreated waste is released in open, in and around the complex, then it can have disastrous consequences. In the instant case, it was contended that around 350 hectares of land that has been contaminated, and not only that the land has been contaminated, but these chemicals have percolated so deep into the bowels of the earth that the water table has got contaminated and the water has become unfit for use by humans, animals, or even for irrigation. Taking note of this situation, court applied application of polluter pays principle and directed these industries to bear the cost of remedial measures and compensation for damage caused. Ordered them to pay the compensation for the damage caused by their activities. Court ordered the closure of all those industries which were not complying with the norms and which were causing high pollution, high degree of pollution. Court also ordered the government to take note that such industries are not allowed to operate and no new industry is allowed to commence business unless they comply with environment protection norms. So students, we have learnt in this module various rules dealing with hazardous waste. Not only we have learnt hazardous waste rules, but also we have worked upon, we have discussed hazardous processes listed under the Factories Act, which include use of hazardous waste. We also discussed the responsibilities under various rules, whether these are atomic energy safe disposal of radioactive waste rules, or whether they are the rules of 2016 or construction and demolition waste rules, or maybe import of hazardous chemical rules. We have discussed the legal regime for the disposal of hazardous waste, and we have also discussed what shall be the responsibilities of various categories of persons, like the manufacturer of lead acid batteries, the recycler of lead acid batteries, or even the consumer. Thank you.